Welcome to the Dummy Kruger channel, everyone. In today's video, we head to a United States Coast Guard training center located in Mobile, Alabama, to do a deep dive into a recently failed attempt by First Amendment auditor Rogue Nation to sue two police officers for alleged First and Fourth Amendment violations while he performed one of his First Amendment audits. We're going to mainly focus on the summary judgment that was granted in this case, which will go over a part of Rogue's arguments, part of the defense's arguments, and the finding by the judge. This finding has been known for a few months and discussed on other channels, but two things have happened since then. First, Rogue appealed the finding and that has since crashed and burned. And second, Rogue was hit with a hefty fee of almost $3,000 after the summary judgment was decided. This video will consist of covering a lot of court documents with clips from his audit intertwined. Be forewarned, the video will contain lots of reading while going over his case, so it's not quite as action-packed as you may be used to. However, if you are like me and are interested in their arguments in a legal sense, this case has it all. You'll see the judge tackle so many arguments that a lot of us hear daily while watching these auditors, including things like right-of-way access, easements, trespassing, a form analysis, reasonable articulable suspicion, IDing with a social security number, qualified immunity, interference with only being a physical act, time, place, and manner, and many others. In just this one case alone, so many of these First Amendment auditing arguments get shredded to pieces by the judge. Really quickly before we get to the summary judgment, let's take a quick look at some of what the defense attorney wrote in their motion for summary judgment, because they didn't hold back. So the defense started off their motion like this: the present matter is brought before this court not to address some legitimate violation of constitutional rights or privileges, but for the purposes of generating YouTube ad revenue, ultimately wasting this court's time and resources, along with that of the defendants and the citizens of Mobile, Alabama. The interaction leading to the alleged rights violations was not the result of some rogue or out-of-control police action, but the result of the plaintiff's own purposely directed and inflammatory conduct in interacting with USCG security personnel and filming onto a military installation. As a result, the City of Mobile police were called to investigate a potential criminal trespass onto federal property and potential illegal filming of a designated military installation. The defense continued. Ultimately, Metz's claims are due to be dismissed as the plaintiff's constitutional rights were not violated and defendants are entitled to qualified immunity. There is no doubt that, at least, the defendants were performing discretionary functions at the time of the incident, and their conduct did not violate any clearly established statutory or constitutional rights of which a reasonable person would have known. So this motion by the defense was 30 pages long, but it was mostly covered by the judge in the summary judgment. Let's jump straight to that. Starting with the introduction, plaintiff's claims stem from an incident that occurred near the front gate to the United States Coast Guard Aviation Training Center located on Tanner Williams Road in Mobile, Alabama. Plaintiff George Metz, a full-time YouTube content creator from Florida, is the current owner and operator of a YouTube channel called Rogue Nation. Through that YouTube channel, plaintiff publishes videos of himself performing what he terms as First Amendment, quote, audits. The quotation marks there you could almost feel through the paper. According to plaintiff, a First Amendment auditor is someone that goes around to, again, test the knowledge and make sure that rights are being upheld and, people are acting the way they should be and treating citizens how they should be treated. As summarized by Chief U.S. Magistrate Judge Stephen Doyle, plaintiff, quote, films various government buildings in what appears to be multiple attempts to provoke potentially unlawful police responses. Notice what they are quoting here. It says, see Metz versus Dodson. Metz versus Dodson is, of course, another lawsuit filed by Rogue Nation, which I can't imagine is going well after reading just this one sentence. The case currently before this court arises out of one of these audits, which was recorded, edited, and then posted on plaintiff's YouTube page. As described more fully herein, on October 13, 2020, defendants were called to the USCG facility to investigate a report of trespassing on USCG property and, upon arrival, encountered plaintiff. Plaintiff has brought a claim against defendant Milne for an alleged violation of his Fourth Amendment rights and a claim against defendant Kelly for an alleged violation of his First Amendment rights. Plaintiff seeks damages from these defendants in their individual capacities as a result of these alleged violations. On the other hand, defendants contend that they are entitled to a summary judgment because plaintiffs' constitutional rights were not violated and because they are entitled to qualified immunity. Defendants aver that the evidence is undisputed that they were performing discretionary functions at the time of the incident and that their conduct did not violate any clearly established statutory or constitutional rights of which a reasonable person would have known. Okay, let's jump to the undisputed facts. The undisputed facts are, of course, the facts that aren't disputed by the plaintiff or the defense. On October 13, 2020, plaintiff approached the USCG facility located at Tanner Williams Road, Mobile, Alabama. The plaintiff drove to the area and parked his van on the side of Foster Road near the entrance of the USCG facility, and then approached the facility on foot.
Look like the Sarge has already come down here.
Plaintiff approached the entrance to the facility and its related guardhouse by walking alongside the grass of the fence surrounding the facility on the side of Tanner Williams Road on which the facility is located.
Hey guys, Rogue Nation with you. I'm out here in Mobile, Alabama, solo today. We are coming up on the United States Coast Guard Aviation Training Center, Mobile, Alabama, U.S. Department of Homeland Security. We are on the side of the road.
As he walked closer to the entrance, carrying a video camera and wearing a dark shirt with red writing, a hat, sunglasses, and a black face mask depicting a middle finger gesture made of the words, "Fuck you." Plaintiff filmed onto the USCG facility, highlighting both the USCG facility sign as well as vehicles entering and exiting the base.
Got some warning signs here. U.S. government property, no trespassing. Got the little guard check here. I don't know if anybody's in there or not.
After reaching the entrance to the base, plaintiff stopped and filmed warning signs and notices located at the base entrance, including warning notices which stated, quote, U.S. Coast Guard property, authorized personnel only. Entry into this area constitutes consent to search of personnel and the property under their control. And, quote, U.S. government property, no trespassing. After he filmed the notice/warning signs, plaintiff walked across the paved entrance to the facility and took up a position next to a light pole on the other side of the entrance, immediately next to the USCG facility security fence. He then resumed filming the inside of the USCG facility.
So I continue to walk. I'm going to stand over here on the easement right next to the pole here. I want to block authorized personnel entry, consent to search of personnel and property under their control. So I want to be careful about that.
Almost immediately, non-party USCG security guard Davis approached plaintiff from the guardhouse and informed him that he, quote, cannot film here, and to, quote, get off the property because it's a, quote, military installation.
Sir, you can't film here. Okay, you gotta get off the property. You cannot film here. Get off of the property. You cannot film here. This is a military installation.
At 8:45 a.m., Davis placed a call to emergency dispatch requesting the assistance of the Mobile Police Department. Davis reported that plaintiff was, quote, trying to film the base, that he was standing, quote, right in front of the gate, and that he had informed plaintiff to, quote, leave a couple of times. Immediately thereafter, another USCG security guard, non-party Jonathan Shelton, arrived in a patrol vehicle, pushed Metz off the paved portion of the base entranceway and onto the grass next to the security fence, and again told him to leave the property. Plaintiff refused, stating he was not on USCG property, but rather public property, and instructed Shelton to, quote, call the fucking police, dipshit.
Get your hands off. Get the fuck on the base and get your fucking hands off.
You're on property now.
I am not. This is a public fucking use of way. Get the fuck out of here. Call the police. Call the fucking police.
You are on the property now.
Call the fucking police,
we will.
dipshit.
Yeah.
Touch me again, you're going to jail for assault.
Okay.
They're going the other way.
Yep. Go. Get the fuck out.
I'm not getting the fuck off. You're still on property. Get on the sidewalk.
Get the fuck away from me. COVID, 6 feet. Get the fuck back.
You're the one that's on our property.
Yep. Get the fuck back. The street, your fucking property?
Right,
You're not even on the street.
You can go across there, but you're on the property.
No,
now.
you guys are going to learn today about public's ease, right of
Like I
ease,
said.
okay? This is a fucking public street. I'm allowed to be on the side of the road.
Get on the street.
No, I'm not on the street.
What does it say right
Get
there?
hit.
You taped it, right?
Yeah.
So therefore,
U.S. property, no trespassing. Now ask your
what do you do?
fucking.
You're trespassing.
Now ask
I'm
your.
not gonna discuss it with you.
Ask
Just
your
shut up.
dumb
Just shut
ass.
the fuck up.
Why isn't the fence out here,
Like I said,
asshole?
All of this is our property.
Why isn't the fence out here, asshole? Because the public has a right to walk down the fucking side of the road without being in the fucking road.
We'll have to break the film on the government property.
Additionally, at 9 a.m., USCG Petty Officer Bradley made a call to emergency dispatch. Bradley informed emergency dispatch that plaintiff was, quote, on base and, quote, technically on our property, filming with a professional camera, and he also requested MPD assistance to remove plaintiff from our, quote, particular property. He also noted that plaintiff was not allowed to video the base from on their property. He also noted that plaintiff was not allowed to video the base from on, quote, their property. When asked where plaintiff was located, Bradley indicated that he was, quote, right on our front gate on Tanner Williams. He's actually, kind of getting a little fighty with our security guard right now, unquote. He further noted that the situation was, quote, starting to escalate and that MPD, quote, might want to hurry up. Bradley was asked whether plaintiff was on USCG property, to which he responded, quote, technically yes, he is on our side. That if he was on the other side of the road, that they would not be able to do much, and that plaintiff was, quote, standing on our grass, cussing at our security guards. At approximately 9:01 a.m., MPD officers Kimberly Kilburn and Milne arrived on scene. After his arrival, Milne began an investigation. He said during a deposition, "When I arrived on scene, I spoke with personnel working as security for the Coast Guard base. They informed me that an individual, you, were trespassing on their property and that they had to remove you from their driveway to the position that you were in at the time, which was a grassy area up against the fence of the Coast Guard base, and they stated that you were still on their property." Continuing, after observing the scene and speaking with USCG personnel, Kilburn and Milne approached plaintiff and asked him, quote, what is going on, to which he explained that he was doing a, quote, constitutionally protected activity and that Shelton needed to be arrested for assaulting him, quote, off base.
Hey, bud. What we got going on today?
This is what you see, a constitutionally protected activity in a place I'm legally allowed to be. This man needs to be arrested for assaulting me off base.
Milne explained that where plaintiff was standing is not public property and that it is instead USCG property. Plaintiff immediately requested that a supervisor respond to the scene.
Okay, but it's his base, so
He's off base?
No.
This is a public road. This is called
this
a...
right here,
Yes.
that's their property.
Oh, so it's
That's
not
federal property.
It's not a public use?
No.
The public can't walk down the road. We gotta
You
walk down
can
the road?
until he tells you that you can't be here because
Yeah,
you're
you
on
need
his
to-
property.
I need a
So do you have your
supervisor.
ID?
I need a supervisor.
I need your ID.
Officers Kilburn and Milne then requested plaintiff to produce an ID and stated that they were performing an investigation related to potential trespassing. Plaintiff refused to provide an ID, stating that he does not have one, and again demanded that Milne request a supervisor.
I need a supervisor.
I need your ID.
Go ahead and give us an ID.
What's the crime?
Trespassing.
Trespassing.
Yes, sir. So I need to see your ID.
I don't have an ID on me. I need to see a supervisor. You're required to get a supervisor when I request one.
Okay, I can get you a supervisor right after you tell me who you are.
Milne responded that he would provide a supervisor after plaintiff provided his information, and when plaintiff stated that he was, quote, not legally required to tell you who I am, Milne stated that he would arrest him for trespassing if he did not provide his personal information.
Okay, I can get you a supervisor right after you tell me who you are.
I'm not
you are, or you're going to be under arrest for trespassing. So
if I don't tell you who I am, I'm going to be under arrest for trespassing.
yeah, and we'll take you to Metro. We'll write you down as John Doe, and then you can stay until you tell them who you are.
Oh,
But that's
no.
up to you.
No, absolutely.
Plaintiff provided his name and last name and date of birth to Milne.
As soon as you threaten me with arrest, that's a violation of my Fourth Amendment. Go ahead and take down my information.
What's your first and last name?
George Metz. What's your name?
I'll get you my name. How do you spell your last name?
M-E-T-Z. Is it C. Milne? M-I-L?
Milne. M-E-T-Z. What's your date of birth, Mr. Metz?
278.
Milne then asked plaintiff for either his social security number or his driver's license number, but plaintiff refused to provide either, stating that asking for his social security number was a violation of the, quote, 1974 Privacy Act, and again demanded to speak to a supervisor.
Okay, what's your social?
I don't need to give that to you. It's not required. Please give me a supervisor.
It is required.
No, it's not. As a matter of fact, it's against the law under the 1974 Privacy Act. Yes, it is. Get a supervisor.
Okay. No, we're not doing that yet. You're going to tell me either your ID number if you have an Alabama driver's license, or you're going to tell me your social. That's what's going to happen. I cannot identify you from your name and your date of birth.
What's the state statute say? What's required?
All right, man. Do you just want to go to jail for trespassing? Is that what it is? Are you just trying to make a statement out here? Because that's fine.
I do this all over the country. I'm sponsored by a lawyer. I'm well versed in the law, my friend.
Okay, that's fine. Do you have an Alabama driver's license, or are you
Nope.
from the state?
Nope.
No? Okay, so you're just going to continue to refuse to cooperate, or?
I've cooperated. I gave you my name and date of birth. That's all that's required
No.
by law.
It's not.
What else is required?
Like I said, you got to give me your social so I can
Okay.
identify you.
Okay, go ahead. Take down my social. I want the supervisor here now.
It does.
Yeah, you'll find out. Go ahead and get a supervisor here.
Eventually, plaintiff provided his social security number to Milne, who called plaintiff's information into MPD to continue his investigation.
So what is the purpose?
I'm answering no more questions.
Okay.
Supervisor. This guy just earned himself a lawsuit. Idiots. Don't forget your part about putting your hands all on me and touching me and my camera.
You guys not on file?
Milne, through MPD dispatch, ran the information provided by plaintiff under one of the MPD systems, but was unable to find any information identifying the plaintiff.
You said your social's 311. Okay. Do you not have any kind of ID at all anywhere in the United States?
I'm not answering any more questions from you. I gave you
Okay,
what was legally
that's the
required.
thing. Yeah, but none of this is coming back.
I can't help you. It's a problem with your system.
No, it's a problem with the information you gave me. Either you gave me false information, or you can try and help yourself out here and give me the correct information, or try and help me figure out why this information's not coming back.
I don't know what's wrong with your system. I don't work in technology. Maybe your supervisor can help when he gets here. You guys got like, what, 6 weeks of law training? It's clear you don't know what the f***'s going on.
After some time, plaintiff asked Kilburn if he was being detained, and she stated that he was, quote, for right now, until MPD was able to confirm his identity.
I'm being detained? Yes?
Yeah, for right now.
Okay. Detained for the crime of trespassing? Yeah.
However, plaintiff was never placed in handcuffs, was never physically touched, was never escorted to a squad car, and was never arrested. Plaintiff testified that at this point, he had been on the scene for approximately 20 minutes and further testified that even if he had not been detained, he would most likely have stayed anyway to speak to Sergeant Kelly. Kilburn continued an investigation to attempt to identify plaintiff, which was eventually successful.
Once we find out that I'm legal to be right here, I'll need to press charges on the captain of the security for assaulting me, battering me out here, outside of his jurisdiction. There's a reason why that fence doesn't come out to here. Can't just walk up to somebody, Shelton, and start putting your hands on him. You realize that, right?
mess up.
You can't just walk up to somebody and put your fucking hands on them, man. They training you guys to take social security numbers?
When we identify people, yes.
Absolutely. So you do it every time?
Every single time.
And that's a training policy of your department?
That's the only way that I can verifiably identify you.
Really?
Yes.
So how do cops do it in other states? They take social security
I don't know how
numbers?
they do it in other states. I work for the state of Alabama and the city of Mobile.
Any lawsuits yet?
Nope.
No? You just earned your first one.
Okay.
I'm assuming you're American, right?
Yes, I'm American.
Do you know the right to free press?
That's perfectly fine. You don't have a right to trespass on other people's property.
I'm just asking you if you know what the right to free press is.
Sure.
Okay. That'll take away your qualified immunity.
Okay, cool.
They ran all my records. They know who I am. Been stopped numerous times here in Alabama. I was stopped in front of the FBI last year here in Mobile. They wrote me a ticket. It's kind of hard to see how you guys can't find me.
Do you not want to speak to a supervisor?
No, I do. I was just legally. Am I still being detained? You guys?
You're still being investigated for the trespassing, so yeah.
Okay. Are you investigating here, or I don't see you doing any investigating now?
Yeah, we're just standing by.
Okay.
Thereafter, Sergeant Kelly arrived on the scene and, after briefly conferring with the officers and USCG personnel, told plaintiff that the USCG was stating that where he was standing is part of their property and that if he wanted to film, he needed to go across the street.
How you doing?
Good, Sergeant Kelly. How are you?
I'm great. All right. They're claiming this is part of their property, okay?
But you know about public easement, I'm sure.
If you want to film what's going on over here, go right over there, across the street.
So this is not public right away. The public has no right to walk on this.
They're claiming this is part of their property. I haven't seen the deed. I don't know. So if you want to film what's going on this base, go across the street.
Isn't that private property?
Go across the street.
Is that private?
See where that sign is right there? That big tank thing looking thing?
Oh, that's
that big metal thing?
That's public
Then
easement?
you can go right there. That's public easement. They can't say nothing to you. If you want to go over there, go over there.
Is this not public easement?
Over there is.
I'm just asking.
They're claiming this is their property, so that's all I have. Okay?
Oh, so so just
So
take their word.
are you understanding what I'm saying?
I hear what you're saying.
Okay, go over there.
Okay. Can I stand on the street?
No,
Why not?
because then you're blocking the street, and you can go to jail for disorderly conduct for that.
All right.
You're gonna film, and you're gonna do this. Go across the street.
Okay. So this is
Okay.
their property. No one's
This
allowed
is
on
their
it.
property. They don't want you on their property. Go across the street.
Perfect.
Milne then accompanied plaintiff as he willingly crossed the street while continuing to film the officers, who he described as, quote, fucking idiots.
Thanks. I didn't need an escort. Fucking idiots.
After filming the police officers leaving the entrance to the USCG facility, plaintiff stated, quote, looks like they didn't end up learning anything anyway, so we're definitely going to have to take this to the next level here.
All right, looks like the coppers are out of here. Looks like they didn't end up learning anything anyway, so we're definitely going to have to take this to the next level here.
Plaintiff then proceeded to his vehicle, which was parked on Foster Road near the base, and found 3 MPD patrol vehicles idling behind his vehicle.
Look like the Sarge has already come down here.
Plaintiff asked Kilburn if there was an issue, and she told them that they were running the tag attempting to obtain ownership information for the vehicle. Plaintiff attempted to enter the vehicle and was instructed to wait to get into the vehicle by Kilburn.
Is there an issue?
Huh?
Is there an issue?
Just an abandoned vehicle.
Huh? That's not abandoned. You guys know who it is. It's got a tag on it. It's registered to me. Thank you, though.
Hang on, buddy.
Am I not allowed to get in my car?
At that time, Milne was running the tag on the vehicle and it came back registered to a red vehicle, which led Kelly to believe it was a switch tag.
Am I being detained?
Hang on just a minute for me, bud.
Yes or no? Am I allowed to get in my vehicle?
Well, how do we know this is your vehicle?
It's got my tag on it. You ran it.
Is it your tag?
You guys
I
want
think I heard him say on the radio it was a switch tag.
to? Yeah, sure. Sure you did. My lawyer's gonna love this.
Is your ride?
Yep,
Oh, okay.
that's what the tag says. You got any reason to suspect it's not?
Say again?
Any reason to suspect it's not?
No, sir.
Can I get in and leave?
Yes.
Thank
wanna
you.
leave, go right ahead.
Get out of my way, thank you.
To determine whether the vehicle was properly registered to plaintiff, Kelly asked plaintiff if it was his vehicle, to which he responded that it was. Kelly then approached the vehicle and observed the VIN number to confirm the match. After Kelly determined that the vehicle was registered to plaintiff, the officers allowed plaintiff to get in his vehicle and leave, thus ending the encounter. Plaintiff has admitted that he was not damaged at any point and is only seeking punitive damages from the incident. So that was the extent of the incident that led to this lawsuit. Now, let's take a look at the analysis. Based on his complaint, plaintiff seemingly claims violations of his First and Fourth Amendment rights based on the actions of defendants. Defendants submit that they did not violate plaintiff's constitutional rights. In the alternative, defendants claim that they are entitled to qualified immunity. The qualified immunity doctrine seeks to balance, quote, the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Qualified immunity protects government officials who are sued in their individual capacities if they are, quote, engaged in discretionary functions, unless they violate, quote, clearly established federal statutory or constitutional rights of which a reasonable person would have known. Moving down, unless the government official's act is so obviously wrong in the light of pre-existing law that only a plainly incompetent official or one who was knowingly violating the law would have committed the act, the official is entitled to qualified immunity. Continuing, to be entitled to qualified immunity, the government official must first show that he was acting within the scope of his discretionary authority when the alleged unconstitutional acts occurred. The term discretionary authority covers all actions of a government official that 1. Were undertaken pursuant to the performance of his duties, and 2. Were within the scope of his authority. Once the defendant establishes that he was acting within his discretionary authority, the burden shifts to the plaintiff to demonstrate that qualified immunity is inappropriate. To do so, the plaintiff must prove 1. That the government official violated a constitutional right, and 2. That the constitutional right was clearly established at the time of the official's actions. In his complaint, plaintiff argues that Milne violated his Fourth Amendment right to be free from unlawful seizure and search. Specifically, plaintiff asserted that because he was engaged in a constitutionally protected activity, filming portions of the USCG base as a YouTube content creator, Milne did not have a reasonable suspicion of criminal activity and, therefore, no right to detain or ID him. Plaintiff specifically takes issue with Milne's request for a social security number to identify plaintiff because plaintiff claimed that he did not have a driver's license or other written identification. Milne contends that he is entitled to summary judgment on this claim on the following grounds. 1. He did not violate plaintiff's constitutional rights, and 2. He is entitled to qualified immunity. First, the judge will tackle the discretionary function. To prove that a police officer was performing a discretionary function, it must be shown that the police officer was A. performing a legitimate job-related function, that is, pursuing a job-related goal, and B. through his means that were within his power to utilize. Plaintiff has not disputed Milne's argument that he was performing a discretionary function during his interaction with plaintiff. It is undisputed that Milne was employed with the MPD on the date of the incident, was in uniform, was dispatched along with Kilburn to respond to 2 separate emergency calls placed by USCG personnel, and interacted with USCG personnel and plaintiff at the scene as part of a routine police investigation into plaintiff's alleged criminal conduct, trespass. Plaintiff's complaint identifies Milne and Kilburn as officers upon their arrival at the scene. Milne was indisputably, quote, performing a job-related function by responding to an emergency calls regarding potential criminal activity and investigating same as part of his employment as the police officer with MPD. Because Milne was performing a discretionary function, the burden shifts to plaintiff to demonstrate that Milne is not entitled to qualified immunity. To show that Milne is not entitled to qualified immunity, plaintiff must prove that Milne, 1, committed a constitutional violation, and 2, that the constitutional right Milne violated was clearly established at the time he did. So, it's pretty obviously Milne was performing a discretionary function in this case. Moving on to Rowe's claim that his Fourth Amendment was violated. Plaintiff has the burden of proving that Milne committed a constitutional violation. As discussed herein, plaintiff has failed to do so. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. However, an individual may be temporarily seized, and seizure alone is not enough for a 1983 liability. The seizure must be, quote, unreasonable. Although not expressly authorized in Terry, United States v. Brignone-Ponce was unequivocal in saying that reasonable suspicion of criminal activity warrants a temporary seizure for the purpose of questioning limited to the purpose of the stop. The determination of whether an officer has reasonable suspicion of criminal activity is a question of law. Quote, we consider the totality of the circumstances in light of the officer's own experience and determine whether the officer can point to specific and articulable facts which, taken together with rational inferences from the facts, support an objectively reasonable suspicion that plaintiff had engaged in a crime. Moreover, when an official asserts qualified immunity for an alleged Fourth Amendment violation, the question is not whether the official had actual reasonable suspicion, but whether the official had arguable reasonable suspicion. At the time of the incident involving plaintiff, Milne was investigating several potential criminal issues. According to 18 U.S.C. 1382, whoever, within the jurisdiction of the United States, goes upon a military, naval, or Coast Guard reservation, post, fort, arsenal, yard, station, or installation for any purpose prohibited by law or lawful regulation shall be fined under this title or imprisoned not more than 6 months or both. Additionally, 18 U.S.C. 795 states that whenever in the interests of national security, the President defines certain vital military and naval installations or equipment as requiring protection against the general dissemination of information relative thereto. It shall be unlawful to make any photograph, sketch, picture, drawing, map, or graphical representation of such vital military and naval installations or equipment without first obtaining permission of the commanding officer of the military or naval post, camp, or station. Furthermore, Alabama Code 13A74 states that a person is guilty of criminal trespass in the third degree when he knowingly enters or remains unlawfully in or upon premises. It is undisputed that USCG officers Davis and Bradley separately called for police to investigate potential criminal activity at the entrance of the base. Davis reported in his call that plaintiff was filming the base, that he was on base property, and that he did not leave after being requested to do so. Bradley informed MPD through dispatch that plaintiff was on USCG property, that he was cussing at USCG security personnel, that he was improperly filming while on base, and that the situation was escalating. Milne testified that upon arrival at the scene, he observed plaintiff standing by the base fence, which was clearly marked as U.S. government property with, quote, no trespassing signs on it. Furthermore, he observed plaintiff with camera equipment filming onto a federal military installation. In addition to the emergency calls and his own observations, Milne spoke with at least 2 and potentially 3 USCG personnel before speaking with plaintiff. Plaintiff contends that the area he was standing on the entrance of the base was a public right-of-way and that Milne should have known this. This argument holds no water in relation to whether he was trespassing on military property. In a case that addressed a similar argument, the Sixth Circuit Court of Appeals stated, quote, but the main driveway of Wurtsmith Air Force Base was not built on land owned by the county. The county's right-of-way may have overlapped the driveway and the adjacent island, but a mere right-of-way, as the trial court noted, quote, is less than ownership. The typical Michigan suburbanite owns the portion of his driveway that lies between the sidewalk and the street, even though that portion of the driveway is burdened by a local government's right-of-way. The right-of-way may cover the suburbanite's entire tree lawn, along with such of the driveway as lies within the tree lawn, but the right-of-way is less than ownership in fee, and the driveway belongs to the homeowner. As far as Wurtsmith Air Force Base is concerned, similarly, Judge Churchill said, quote, there isn't any question that the entire area up to at least the center of the road, if not beyond, is a part of the military base. As a matter of real estate law, that proposition would seem unassailable. The court finds that plaintiff's own conclusion that the area upon which he was standing was a place he had a right to be is not supported by any evidence in the record, especially in the light of the McCoy decision and the fact that at least 3 USCG officials contend otherwise. In addition, the court finds that Milne's brief investigative seizure, and specifically his request for ID and the social security number of plaintiff, was constitutional as it was limited in duration and scope. Quote, a brief stop of a suspicious individual in order to determine his identity or to maintain the status quo momentarily while obtaining more information may be most reasonable in light of the facts known to the officers at the time. And skipping down, quote, if there are articulable facts supporting a reasonable suspicion that a person has committed a criminal offense, that person may be able to be stopped in order to identify him, to question him briefly, or to detain him briefly while attempting to obtain additional information. It is well established that an official may conduct a brief investigatory stop, otherwise known as a quote Terry stop, if he has a reasonable suspicion of criminal activity. Based on the undisputed evidence, the court concludes that Milne had at least arguable reasonable suspicion, if not actual reasonable suspicion, that plaintiff was trespassing on a federal military installation and filming same sufficient to justify a request that plaintiff provide identification. One law enforcement identification system and being unable to come up with any identifying information, Milne requested more identifying information from plaintiff, including his social security number. Although plaintiff admittedly had no ID on him to prove his identity, he argues that he could not be required to provide his social security number for that purpose. The court finds that Milne's request for plaintiff's social security number, under the totality of the circumstances, did not constitute an unreasonable search and seizure given plaintiff's unwillingness to provide identification or other identifying information. Even if the court had not reached this conclusion, the outcome would be the same, however, because plaintiff has not shown and cannot show that the conduct violates clearly established law to request the social security number of an alleged perpetrator who refuses to produce identification. And moving on to the violation of clearly established right. Even if this court found that Milne did violate plaintiff's Fourth Amendment rights, Milne would still be entitled to qualified immunity because plaintiff has not proven the second element of the prong test, that is, that the right was clearly established in a particularized sense. Based on the undisputed evidence concerning the events at the base that day, Milne's actions were objectively reasonable under the circumstances, and, quote, an objectively reasonable officer in the same circumstances and possessing the same knowledge as Milne could have believed that probable cause existed to stop an ID Mets. Given the facts set forth above, Milne had a legitimate interest in stopping plaintiff to investigate potential trespassing and his request for identification, including social security number, JC News Now, to further investigate the situation, and plaintiff's potential criminal history was objectively reasonable under the circumstances. Plaintiff has cited no law in support of his argument and, in fact, in his response did not address the issue of whether the allegedly infringed right here was clearly established at all. The court, however, discovered a federal case from the Central District of California that it finds persuasive. In Williams v. San Bernardino County Sheriff's Department, the plaintiff claimed that the officer defendant was not entitled to qualified immunity because Schweier v. Cox, quote, demonstrated that the law was clearly established that an officer who requested a social security number during an investigatory stop could not elevate a detention to a de facto arrest or even deny a person, quote, any benefit because the individual refused to disclose his social security number. The court there rejected the plaintiff's argument, holding that the Schweier case concerned voting rights and has no clear application to plaintiff's situation. The court concluded that the officer was entitled to qualified immunity, quote, because it does not violate clearly established law to detain a suspect who refuses to provide his social security number. This court likewise concludes that Milne's request for plaintiff to provide his social security number under the circumstances in this case did not violate clearly established law. Based on the foregoing, Milne is entitled to qualified immunity and, accordingly, to summary judgment in his favor. Moving on to the other officer, the court found the exact same thing when it comes to the discretionary function. It writes, the court finds that he, Kelly, was performing a discretionary function at the time of the incident, just like Milne. As for the First Amendment grounds, plaintiff seemingly argues in his complaint that Kelly violated his First Amendment, quote, right to free press on public property when Kelly, quote, kicked him off public property under threat of arrest and asked plaintiff to move across the street from the base to film. However, plaintiff's First Amendment rights were not violated because Kelly's request for plaintiff to move across the street to an area that was not USCG property was a content-neutral restriction on speech in a public forum that was reasonable in time, place, and manner. To determine whether First Amendment rights have been violated, the Supreme Court has espoused a three-pronged analysis. Ask first whether the speech is, quote, protected by the First Amendment. Second, determine the nature of the forum. And third, ask whether the government's, quote, justifications for exclusion from the relevant forum satisfy the requisite standard. In Cornelius versus NAACP, the 11th Circuit has held that, quote, the First Amendment protects the right to gather information about what public officials do on public property, and specifically, a right to record matters of public interest. In particular, we held that the plaintiffs there, quote, had a First Amendment right, subject to reasonable time, manner, and place restrictions, to photograph or videotape police conduct. However, it is decidedly not obvious that Smith's general rule applies to the specific situation in question here. The court need not determine whether plaintiff had any First Amendment right at all to film onto the USCG base, or, indeed, whether plaintiff was trespassing to determine whether his First Amendment rights were violated by Kelly. As discussed supra, according to 3 USCG officers, plaintiff was trespassing on federal property in violation of both federal and state law. The reports of these USCG officials were sufficient to provide Kelly the right to investigate. In U.S. v. Rubio, the Court of Appeals stated that it strongly disagreed with any interference that criminal investigation is somehow prohibited when it interferes with First Amendment interests. When activity protected by the First Amendment becomes the subject of a criminal investigation, the protections afforded by the Fourth Amendment come into play. Even assuming plaintiff's filming of the USCG facility and related personnel was a protected activity under the First Amendment and that he was standing on a public right-of-way, Sergeant Kelly did not violate his First Amendment rights by asking him to move across the street. The First Amendment does not guarantee the right to communicate one's views at all times and places or any manner that may be desired. Okay, let's break away momentarily from this because I want to talk about this footnote here. It reads, the court notes that even if plaintiff was in a public right-of-way when he was filming the base at the time he was asked to relocate, he was still also on federal property which the USCG had the right to control and, by extension, to limit his First Amendment rights. How many videos by First Amendment auditors are there where they claim they can do anything they want on easements or rights of way because they are, quote, public property as long as they are not breaking the law? Hundreds, probably thousands. This has always been one of the sillier notions in my opinion, and the judge obliterated that nonsense with one little footnote. And as a matter of fact, this right-of-way dispute became Rogue's primary concern when opposing the defendant's motion for summary judgment. While the defense argued primarily for qualified immunity, which Rogue seemed to ignore, he instead asserted his right to stand on their property as much as he liked due to a right-of-way. From Rogue's opposition to motion for summary judgment. He writes, the present matter before the court is a legitimate violation of my rights. The defense's whole case hinges on me being on the Coast Guard property, which I clearly was not. In my first exhibit, seen below, is a picture of the tax lines as seen on the government website. As we notice, the Coast Guard base is shaded in pink. We see the right-of-way in gray. Now, this picture was black and white when it came off Pacer, so obviously we can't see any pink. However, we learn shortly that this screenshot is essentially useless because it can't be used in a court of law. More on that momentarily. He continues, while some of the right-of-way is within the tax property line, there is a small sliver of it outside the property line as seen by the gate/road. Defense has presented no evidence that I was on their property, nor can they produce any. Notwithstanding society's basic understanding of the public right-of-way is hundreds of years old. Just off the top of my head, I can recall that most 2-lane county roads in North America are 4-rod roads, each rod being 16.5 feet, meaning a public right-of-way between 60 and 66 feet. By statute, Alabama Code Exhibit 2, seen below, the public right-of-way is a minimum 60 feet in width. Exhibit 3, which we will examine on the next slide, which states I was exactly where I should have been. Officer Milne was kind enough to admit that I could walk down the right-of-way. It boggles my mind that they said Sergeant Kelly could easily determine by his experience and visual evidence to be a utility easement in order to continue his filming of the base. all the while ignoring the utility easement I was standing by near the gate, which they admit is, well, quote, a position next to a light pole on the north side of the entrance, unquote. This is the statute Rogue submitted as an exhibit, and I believe letter C fits this situation best. It reads, where neither a sidewalk nor a shoulder is available, any pedestrian walking along and upon a highway shall walk as near as practicable to an outside edge of the roadway, and if on a two-way roadway, shall walk only to the left side of the roadway. Notice it says, quote, any pedestrian walking along and upon a highway shall walk as near as practicable, unquote. Walk is the key term here. Public rights-of-way gives the public the right to access one's property in specific situations for a limited purpose. In this case, that purpose is walking, not journalisming. So other than the right-of-way argument that Rogue made, the only other argument he made was that they lacked reasonable suspicion. That was it. Nothing about qualified immunity. And the defense noticed. Here's their reply. In support of the defendant's motion for summary judgment, they write A. Plaintiff's response fails to address defendant's qualified immunity defense. Plaintiff's claims are due to be dismissed as defendants are entitled to qualified immunity. Significantly, plaintiff's response fails entirely to address the issue of defendant's qualified immunity. Plaintiff claims in his response that the defense's whole case hinges on my being on the Coast Guard property, which I was not. 1. Plaintiff's assertion is incorrect. Defendant's primary argument is the case hinges on the qualified immunity defense. And then they rehash a lot what's already been discussed in the judge's summary judgment. But that's not all they argued. They also say, B. Plaintiff's argument that he had a right to film on base is not legally viable and not supported by any admissible evidence. Plaintiff claims that defendants violated a clearly established right by preventing him from filming outside of the USCG facility fence, which is located on federal property. Despite plaintiff's claims, plaintiff has failed to present any admissible evidence in response to defendant's motion for summary judgment to support his claims. Although plaintiff may allegedly, quote, know off the top of his head, the purported historical factoid regarding, quote, four-rod roads, which may or not be correct, plaintiff's internalized knowledge is not supported by any law or evidence. Without expending valuable time explaining the nuances of property law, as this court is aware, an easement may grant a right-of-way, but it is, at its heart, a non-possessory interest in land. As such, and arguendo, even if the federal government had granted an easement to the city of Mobile and or county of Mobile, Alabama for the construction of a public right-of-way/roadway, which plaintiff has not proven exists, the USCG would still retain the right to police their property and prevent activities not contemplated in the language of the easement, because easements are limited. Furthermore, plaintiff has not presented and cannot present any admissible evidence which demonstrate he had a legal right to stand on the property. Plaintiff's Exhibit 1, a computer screenshot from the Mobile County Revenue Commission's website, apart from being inadmissible hearsay, can only be accessed by agreeing to a disclaimer that states, quote, this product is for information purposes only and is not suitable for legal purposes. It does not present an on-the-ground survey and shows only the approximate relative location of the property boundaries and other features, a fact the plaintiff recognized during his deposition. From that deposition that took place months earlier, the defense asks, the property tax maps that you looked at prior to going to the Coast Guard base, do you know who manages those? Rogue answers, I believe the county. Okay, and do you remember what website those were on? Rogue says, I believe it would be a county website. The attorney asks, the tax maps, were they maintained by the Revenue Commission to your knowledge? He answers, I believe it would be whoever collects the tax in the county here, Mobile County. I'm going to show you what I'm going to mark as Defendant's Exhibit 17. Even though it says A here, it's another question by the defense. I'll show you a copy. This is a screenshot and I'm going to read the website address, mobilecopropertytax.com, and this is from the Mobile County Revenue Commission. Do you have any reason to believe that this is not from that website? Rogue answers, no, I mean, it looks like what I would have used or what would have came up. Okay, by chance, do you remember whether or not you saw this pop up when you first went to that website? Rogue, I mean, I have no clue. Okay, would you agree reading the disclaimer it says, quote, this product is for informational purposes and not suitable for legal, engineering, or surveying purposes? Would you agree that I read that correctly? And finally, Rogue answers, yes, sir. So Rogue's main defense in his motion is that this screenshot showed he wasn't on the property, yet only months prior conceded that the disclaimer on that same website said it wasn't to be used for legal purposes. Okay, moving on. Back to the defendant's reply in support of motion for summary judgment. In further support of his arguments, plaintiff cites Alabama Code 4549181.10. However, closer inspection of the statute cited reveals that it is merely one of several addressing how citizens of Mobile, Alabama can petition to incorporate unimproved dirt roads into the county road maintenance system, their subsequent improvement, and the installation of related traffic control devices. Although wholly unrelated to this case, plaintiff fails to realize that even this process requires, quote, individual property owners to execute any right-of-way deed or easement documents, as opposed to some amorphous and pseudo-historical general right to a, quote, public right-of-way. Yikes. Lastly, plaintiff asserts he has a right to stand and film the USCG facility based on Alabama Code 355A215C, the one I discussed earlier, which permits pedestrians to walk along a roadway. However, and as discussed above in defendant's motion, plaintiff was not walking along the roadway, but was standing on federal property and, at one point, in the driveway of the USCG facility, and was in fact not traveling down the road. Thus, Alabama Code 355A215 does not apply in this particular instance, because that right-of-way is there for walking. Apologies for veering off the summary judgment topic, but I found this entire exchange quite entertaining. I also wanted to thoroughly review it in case any auditor watches this and tries to use the excuse to justify being on someone else's property, harassing them for Google bucks. There are better arguments out there. This one in particular has always been ridiculous. Saying all of that, I reached out to Rogue Nation if he thought the judge got it wrong in this instance. He got back to me saying, quote, absolutely, title to the land under the right-of-way doesn't matter, unquote. However, the defendants, the judge, and the Sixth Circuit Court of Appeals all had a different opinion. I'm linking this U.S. v. McCoy decision below as I found it a very interesting read. I also asked Rogue why he just stuck with this argument and didn't touch on the defendant's main argument of qualified immunity. He said, quote, qualified immunity is their defense, not mine. Looking back on the summary judgment, the judge wrote, once the defendant establishes that he was acting within his discretionary authority, which they did, the burden shifts to the plaintiff, Rogue Nation, to demonstrate that qualified immunity is inappropriate. So, when the argument comes down to qualified immunity, and if the defendant was able to establish they were acting within their discretionary authority, if you want to win your case, you have to argue that qualified immunity is inappropriate in this situation. Rogue never took those steps. Now that that's out of the way, let's quickly jump back to the judge where we are almost finished. All activities protected by the First Amendment are subject to reasonable time, place, and manner restrictions. We have often approved restrictions of that kind, time, place, and manner, provided that they are justified without reference to the content of the regulated speech, that they serve a significant governmental interest, and that in doing so they leave open ample alternative channels for communication of the information. Each of these requirements were satisfied by Milne and Sergeant Kelly. First, Sergeant Kelly's demand for plaintiff to relocate and continue his activity across the street was content neutral. In fact, defendants never asked plaintiff what he was doing, what the subject of his filming was, what the purpose of his filming was, or any other question that would shed light on the content of plaintiff's First Amendment activity. Defendant's issue with plaintiff was not his activity, but his location, specifically that he was reportedly on the USCG facility without permission and trespassing onto federal, non-public property. Sergeant Kelly's, quote, regulation of plaintiff's, quote, speech was clearly content neutral. Second, Sergeant Kelly's demand for plaintiff to move across the street served a significant governmental interest in keeping plaintiff from disrupting the flow of vehicular traffic going into the base and allowing USCG security guards to focus on their duties. Plaintiff was standing directly next to the driveway leading to the guardhouse at the entryway of the USCG facility. Plaintiffs present in close proximity to the entrance to the base caused USCG security guards to divert attention to him rather than focus on the vehicles approaching the guardhouse. In this way, plaintiff was interfering with USCG security guards' performance of their duties. Relocating plaintiff across the street relieved the issues posed to the flow of traffic and permitted USCG security guards to focus on their duties, both of which are significant governmental interests. See United States v. Corrigan. Military officials need not demonstrate actual harm before implementing a regulation restricting speech and may act to forestall reasonable anticipated harm to morale or to the orderly function of the base. Finally, Sergeant Kelly's restrictions were narrowly tailored to serve these substantial governmental interests. Plaintiff was not prohibited from speaking or filming at any time. He was merely asked to move approximately 30 feet away, just across the street, where he was permitted to continue speaking and filming. Plaintiff was still able to reach his intended audience from across the street. Based on the foregoing, the court finds that Kelly's actions in requesting plaintiff to relocate were content neutral and narrowly tailored in time, place, and manner. Accordingly, the court concludes that Kelly did not violate plaintiff's First Amendment rights. And just like with Milne, the judge found that there was no violation of a clearly established right by Kelly. I'm not going to read all of this because it touches on a lot of the same subjects that we already talked with Officer Milne. But he did finish up. Based on the foregoing, the court concludes that plaintiff's First Amendment claim against Kelly, who is acting within his discretionary function as an MPD officer, fails because Kelly is entitled to qualified immunity. Summary judgment in Kelly's favor is therefore proper on plaintiff's First Amendment claim against him. And finally, for the reasons stated herein, it is ordered that the motion for summary judgment filed by defendants Clarence Milne and Sergeant Michael Kelly is hereby granted. So, after Rogue lost, he vowed to appeal, and he did take the necessary initial step. He submitted his notice of appeal with the 11th Circuit, but didn't include the filing fee. What he did instead was file a motion for leave to appeal forma pauperis, attempting to get the $505 filing fee waived. After Rogue submitted his financial information, the court came back writing, based on the information provided by plaintiff, the court finds that the payment of $505 filing fee here would not deprive plaintiff of the basic necessities of life, and that he does have the means to pay the filing fee for this action. Accordingly, plaintiff's motion for leave to appeal in forma pauperis is denied. Approximately a month and a half after this denial, a dismissal was issued, officially killing the lawsuit. I inquired of Rogue why he chose to abandon the lawsuit. He explained that after his appeal to have the fee waived was rejected, he couldn't proceed due to financial constraints. Now, even though the lawsuit was dead, the defense attorneys weren't quite done yet. Back in the circuit court, the defendants submitted a motion to tax costs. From that motion, defendants seek taxation of the costs expended for depositions taken in the case, which totaled $3,680.65. They continued, the only depositions taken in this lawsuit were of plaintiff George Metz and of defendants Clarence Milne and Michael Kelly, and all three depositions were taken on the same date. Pro se plaintiff Metz insisted that he bring his own video camera and record the depositions of defendants. Therefore, it was necessary for defendants to have a court videographer also record their depositions to ensure that true and correct video recordings were made. As defendant's attorney, I felt it was also necessary to have the court videographer make a true and accurate video of plaintiff's deposition. Essentially, the defendants felt it necessary to have these depositions recorded because Rogue insisted on recording them himself. So, to counteract that, they hired a videographer. And this was Rogue's objection. He wrote, "First and foremost, I believe this case raises important legal issues dealing with the First Amendment, and allowing these costs would keep other folks from engaging in litigation to help bring clarity to his issue. Second thing is, I don't think the intent is for the public to reimburse itself, as we have, as taxpayers, already paid the whole bill of the defense through our tax dollars. I have no doubt that the city of Mobile has already paid Burr and Foreman for the costs. Third thing is the fact that their video recordings were not needed, nor were they used, as shown in my Exhibit A. They knew beforehand that my recordings were for personal use, thus no need for them to have a video rebuttal." So that was kind of short and sweet for Rogue and lacking in case law. Now, the defense's reply to this was absolutely brutal. Let's take a look. Plaintiff argues that the previously discussed deposition transcripts and related video recordings were, quote, not needed nor were they used. However, plaintiff's statement is without support and further fundamentally incorrect. The deposition transcripts of all three parties were used in defendant's summary judgment motion. Further, as previously noted, the video recordings of the depositions were needed because plaintiff was video recording all of the depositions using his own equipment, and there would be no other way for defendants to confirm the accuracy of any video recordings produced, published, or used by plaintiff if defendants did not have their own unedited video of the depositions. While plaintiff may have indicated 4 days prior to deposition that he did not intend at the time to use the depositions at trial, it was not until mid-deposition that plaintiff made counsel for defendants aware that the depositions were for, quote, personal use, i.e., to be posted on his websites for personal aggrandizement and income generation. Yikes. And at the time of deposition, counsel for the defendants was unsure as to how the plaintiff intended to use his video recordings in relation to this matter. Additionally, defendants intended to use the video recordings and deposition transcripts at trial of this matter. Secondly, plaintiff's argument that the granting of defendant's motion to tax costs would have a chilling effect on litigation in the future is meritless. Plaintiff has cited no case law to support the proposition that his potential chilling effect should be considered when determining whether a motion to tax costs is due to be granted as to the prevailing party. Further, the argument in and of itself is not based in fact. The granting of a motion tax costs against this plaintiff will not limit or chill any further individual from bringing pro se 1983 claims against Mobile Police Department officers for alleged violations of rights due to arrest or improper investigation, and plaintiff has presented no evidence to contradict same. However, it may only prevent the plaintiff and his ilk from bringing further meritless and financially wasteful claims against public officials related to their manufactured and aggressive confrontations, and further prevent them from earning YouTube revenue. Whew. I think they officially had enough of Rogue's nonsense. A couple of months after these were written, the court finally made its decision, granting the defense their motion partially. First, the court finds that the depositions of Plaintiff Metz, Defendant Milne, and Defendant Kelly were necessarily obtained and were used in support of defendant's successful pretrial motion. The issue presented is whether videotape depositions were necessary. Defendants explained that videotaped depositions were necessary in this case because plaintiff, who was proceeding pro se, insisted on videoing the depositions himself. The court finds defendant's argument persuasive under the circumstances of this action in which plaintiff's motivations were somewhat suspect. Plaintiff's arguments that defendants knew he intended to use his videos for personal use fails to sway the court otherwise. The court finds that the defendants' need to preserve the integrity of the depositions was reasonable and necessary here, as without official videotape depositions, defendants would have no recourse if plaintiff's videotapes were altered or edited. The court did adjust the amount down, but it was granted for a total of $2,755.65 that Rogue Nation still owes to this day. I asked Rogue about these costs. He said the defense attorney was, quote, a shyster charging me for BS, and no, I ain't paid it yet, unquote. So this almost $3,000 was another reason I decided to make this video, as there are lots of pitfalls pro se litigants could potentially find themselves in. I felt this was important to discuss because Rogue has entered in what he dubs Phase 2 of his, quote, activism. Phase 2 seems to be about teaching others how to file their own lawsuits, something he intends to still do after this result. Take a look at this clip.
So we're going to go over the... Rogue, tell us what we're going to go over exactly.
We are going to go over the botany of a marble lava fly. We're going to address starting a pro se lawsuit for yourself, what's needed, what documents you have to file, some of the case law.
The person recording this clip has a YouTube channel called the J-Town Press, and last week she filed a lawsuit where she is proceeding pro se. She's asking for $100,000 in punitive damages for being trespassed from the Clay County, Florida Utility Authority, obviously infringing on her rights to creep around the building filming in windows.
I decided to check the grounds outside around the building. At no time was I in a restricted area. I checked the grounds as well as looked into any open window to see if the employees were working or playing on Facebook.
Since this trespass in Florida, she has now been trespassed from half of Alabama, so she may be busy for some time. Which brings me back to what the defense attorney said in their reply to Rogue's opposition to motion to tax costs that resulted in the $3,000 fee. They wrote this. However, it may only prevent the plaintiff and his ilk from bringing further meritless and financially wasteful claims against public officials related to their manufactured and aggressive confrontations, and further prevent them from earning YouTube revenue. I just have to say, I think this attorney nailed it here. Watch out for those depots, Lana. Alright, I think we can finally wrap up this video that went on way too long. This is Dummy Kruger, and I'll see you on the next one.